My Lord, with the indulgence of my learned friend who said I could have 30 seconds, kindly said I could have 30 seconds, I just wanted to answer my Lord Justice Popplewell's question about whether there was any permission to appeal, necessity, if you like, or whether an appeal at both levels was automatic. The answer to that I've received on instructions is that there's no permission to appeal requirement, so it is, if you like, automatic. When it goes from the Court of Appeal, Federal Court of Appeal, to the STJ, it's quite a strict standard. It's only on the point of law, but there's no permission stage, if you like. The relevant evidence that we have is Resec 1 at paragraphs 47 and 49. And the only other point I would add is that it's accepted that there's no automatic stay that's imposed when you appeal, which means that you could get on with liquidation proceedings in the meantime if there was a generic sentence. There is, however, an expert debate about whether, if you applied for a stay, you would get one. And that's dealt with in Didier 2 at paragraph 32C, which is at L tab 37, page 2357.
And that gives us a reference to Rosa, does it?
Well, Didier 2, exactly. In that paragraph, he deals with Rosa's evidence.
Thank you.
And I'm obliged to my learned friend for the 30 seconds.
Very generous of you, Mr. Chuchoy.
Well, I'm known for being generous. May I start with abuse of process first? Some general considerations of principle before I turn to some facts, and then finally a short summary of our case in relation to abuse, which I hope will cover the main points that were addressed by Mr. Gibson. We accept that the question of abuse of process is ultimately an objective one, and that where a claimant has no realistic prospect of achieving better redress against a defendant than is already available from a different defendant or a mediation scheme, the court may potentially find the claim to be abusive. But special care is required, we say, with this type of abuse argument, especially insofar as it relies on the existence of a claim against another defendant. I'll come separately to the situation where there is an alternative means of redress through a scheme. But so far as the multi-defendant situation is concerned, first, the normal position is that where a claimant has viable causes of action against two or more defendants who are concurrent tortfeasors or wrongdoers, it is none of the business of the defendants or the court to tell the claimant which of the defendants to sue. It would certainly be extraordinary if D1 could have a perfectly arguable claim against it struck out on the mere basis that the claimant also has an arguable claim against D2. It would not normally lie in D1's mouth to say, you, claimant, should sue the other defendant rather than me, because the other defendant is an easier target. The existence of a claim against D2, where D1 and D2 are concurrent tortfeasors, could never be relied upon by D1 as a defense to a claim against it. Even the claimant's ability to pursue a claim against D2 and the failure to pursue such a claim could not normally form the basis of a defense of failure to mitigate loss as against the claimant, because a claimant is not normally required to engage in litigation against others in order to mitigate its loss. Even where D2 would apparently be willing to make some admissions in any hypothetical proceedings against it, because, as in the present case, it so happens, and this is the rather extraordinary feature of this case, it so happens that D2 is ultimately owned and controlled by D1, there may still be perfectly good reasons why it would not be abusive for the claimant to wish to sue D1 rather than D2. For example, because D2's admission is partial only and would not obviate the need for a trial in any event, because D2 is based in a jurisdiction where the available court procedures are not as flexible or sophisticated as those available where D1 can be sued, or because there may be reasonable doubts as to D2's ability to satisfy fully the judgment in the claimant's favor, whereas D1's ability to pay may be beyond question. Or a claim against D1 may possibly produce a better settlement than a claim against D2. For example, because D1 may have a more powerful incentive for settling rather than taking its chances in a public trial. I will come back to some of those themes on the particular facts of our case, but in principle, considerations such as these show that there may be diverse and legitimate reasons why, when a claimant has viable claims against several defendants jointly and severally, the claimant should normally be entitled to choose which defendant to sue, without the court intervening to impose its own view of which defendant the claimant should sue, or effectively seek to restrict the claimant to suing a specific defendant only. Second overall point I want to make is that in those rare cases where the court has interfered with the claimant's choice as to which defendant to sue, it has only done so where the cost-benefit analysis to be carried out by the court on a strikeout basis could be easily and readily carried out on the evidence. Superficially, Wyeth could be said to be such a case, although, as I'll explain in a moment, in fact, Wyeth was not a case about a comparative assessment of the worth or the value in suing one defendant as opposed to another. It was a different kind of exercise involved in Wyeth. But nevertheless, the general proposition that if the court is ever to embark upon this kind of analysis, it should only be in very clear and obvious cases. You can get that from Wyeth itself, the judgment of Lord Justice Stuart Smith. So this is Bundle A of the authorities at tab 1. In particular, if you look at internal page 116.
It's at a glance, is that the phrase?
Yes, beginning in most cases, the second paragraph, yes, exactly. In most cases, it will be quite inappropriate for the court to enter upon the sort of cost-benefit analysis which the judge undertook here. And then if you look at the second sentence, the court cannot weigh the plaintiff's prospect of receiving £1,000 against the defendant's costs of £10,000, which may be irrecoverable. That can only be done at the trial. The third sentence, alternatively, it is a matter for the commercial judgment of the defendant whether he attempts to reach a settlement with the plaintiff. Then if you look at line 8 onwards, beginning one can see at a glance, these, in my respectful submission, are important words. One can see at a glance that the defendants will be put to astronomical expense in defending the claims, and the benefit to the claimant is at best extremely modest, and in all probability nothing. And of course, as we know on the facts of that case, on the undisputed facts, the benefit of success against a very small percentage of the defendants would have been very modest, as was common ground. That's page 11 of the report, the last sentence of paragraph 3. That benefit would have been entirely consumed by the legal aid charges that would have been obtained by the manufacturer defendants against the claimants.
Sorry, it's a reference at page 111 of the report, is it?
Yes, page 111 of the report, the last sentence of the
common
third
ground,
paragraph.
yep.
And then the second point, the one about all potential benefit being consumed by legal aid charges, that's page 112, the penultimate paragraph. And you will recall the particular feature of that case was that there were only claims against the prescriber defendants on the assumption that the claims against the manufacturer defendants had failed, so that by that time the claimants, at least in theory, would have been potentially liable if enforcement of the legal aid charges were permitted. And then the third rather exceptional aspect was prescribers' own costs of defending were said to be, which would have been irrecoverable, were completely out of all proportion to the benefit that stood to be gained by the claimants. But the basis of the decision, as I was saying a moment ago, was not a comparative assessment of the claims against the manufacturers as against the claims against the prescribers. It was a straightforward assessment of the relative costs and benefits of the claims against the prescribers on their own. And moreover, as I think the court debated with Mr. Gibson yesterday, I think, or the day before, there is certainly nothing in Wyeth that stands for the proposition or the theory of any kind of theory of group strikeout, whereby if a group comprises a majority of claims that are abusive, the court can simply strike out all of the claims on the ground that they all belong to the same group.
I mean, there were no material distinctions between the plaintiffs in Wyeth. There were no material distinctions in the plaintiffs in Wyeth, whereas you say there may be material distinctions between the claimants here.
Well, absolutely.
There are, yep.
Okay, for sure. Right. Yes. If there are no, but one would assume that if there are no material differences between the plaintiffs, then whatever ground of strikeout applies to one of them will apply to all of them. The third overall point that I want to make is this. As a matter of policy, the court should be wary of any general principle of abuse whereby it is sufficient to strike out a perfectly viable cause of action that the claimant can sue another defendant who is a concurrent tortfeasor with the existing defendant, even where that other defendant is fully solvent and would be able to meet a judgment on its own. And that's because there would be a serious risk of such a principle giving rise to a form of satellite litigation in which an existing defendant seeks to persuade the court that the claim against it will be so much more difficult or expensive to prove than a claim against an alternative defendant. And that therefore that makes it abusive for the claimant to pursue the existing defendant rather than the alternative defendant. I'm next going to cover, and it may look a little bit disjointed, but I hope the court may find it useful when it comes to drawing together some of the factual aspects of the case. But I've got a few topics that I want to cover. The first is average recovery of a concluded claim, because there was quite a lot of discussion about, for example, the 20-odd thousand whose claims were said to have been concluded. I just want to show you some documents very briefly. You may recall Appendix 1 to Michael 5, which I believe is in the P bundle somewhere. Quickly have a look at that. Maybe tab 8. I'm sorry, I'm told it's Q83. So that's the appendix that summarizes the data that was in the questionnaires filled in by the claimants. If you look at rows 42, 46 in particular, you'll see where some of the figures that are familiar to us come from. So 42, have you initiated a civil claim, and the figure of 67,316.
Sorry, rows 42.
I'm so sorry, that's page 3910. And then if you look at row 44, if you have received a favourable decision, how much was paid? The total amount paid to the claimants who noted their case had been concluded is the 21.3 million. And then if you look at row 46, you will see that in answer to the question, how many claimants said they have received compensation from civil proceedings? It's 18,830. So, and forgive me, 45, you can see what is the status of the lawsuits filed by the individual claimants, and the figure of 19,542 as concluded is recorded there, and of those, it appears that 18,830 said that receive
I don't know
compensation.
how much this matters. There's an obvious oddity that you've got favourably concluded over 21 over. Oh, I see. No, I'm going mad. No, forget it. Sorry.
And if one does the maths, in fact, this data is also quoted in volume 1 at paragraph 447, but I don't think anything turns on that. Doing the maths, this gives an average recovery of 1,130 BRL, which is about £180. I think we might put it at £170 in our skeleton, but that may be because it was a slightly different rate at that point. So 1,130 BRL. So,
what's the significance of that?
well, it's to meet Mr. Gibson's point that all of those claimants obtained full redress. I think.
Well, maybe they
Maybe
did.
they did. I mean, how can we tell?
Well,
those
they may have done. I just want the court to be clear as to.
See, I suspect, only suspecting, these are the great majority of these, both because there's so many and because they resolve comparatively quickly, are water recovery
Yeah,
claims.
absolutely.
And water recovery claims, if it's only a few days, you don't get very much. So,
Yes.
so what?
Yes. No. I just want. I know that. As I said, I'm planning to cover a few factual topics. If I get a lot of so what's, I'll just move on very quickly. But I just want to make sure. It's just that when it comes to facts,
Yeah.
I
Okay,
can't
no,
read your
right.
minds. And
I didn't mean so what offensively, but
I
I wasn't missing some big point. Right.
not two big points so far. And you may want to note, for example, row 49, that is at that point nearly 158,000 of the claimants stated that the compensation they'd received from Renova was not adequate.
The remainder not being those who thought it was adequate, but those who hadn't recovered anything from Renova.
I mean, it would be a bit surprising if a large majority had said we think it was adequate, in which case, why would they be suing? So
Yes.
I think that really advances the argument very much.
Yes. Well, yes. I mean, yeah, obviously, if you're trying to find some evidence of the position, this is as close as it were as you get to it, because obviously, in one sense, the court has from time to time said that both sides have come up with sweeping statements, one way or the other, and you scrape the barrel to find, well, what is the source of that? And this is as good as it gets, I'm afraid. The second factual topic I wanted to cover was in relation to the 100,000 claimants who Mr. Gibson says accepted payment from Renova, and in particular the PIM program. I think the respondent's skeleton at 118, paragraph A, alleged Henderson abuse, even if the claimants had not brought proceedings in Brazil but merely accepted payments from Renova. And I think Mr. Gibson yesterday said that he was no longer relying on Henderson as a separate head of abuse, but was still relying on the availability of Renova for pointless and wasteful abuse. And I think he made a fairly sweeping reference to the availability of redress from Renova, making it abusive to proceed in England. And that's when he referred to the 100,000 figure. I just wanted to show you, or to give you a couple of references which suggest that, again, and you probably won't be surprised by this, that the great majority of the 100,000 appear to have received compensation in respect of PIM, and in particular PIM water rather than PIM general. And you can see that from the Freitas 1, paragraph 9.33a, which is bundle bundle P, tab 77, page 3591. So you can see here 9.338 is where he gives the figures for PIM general. And then if you go to paragraph 8.3 on page 3581, he explains that at October 2013, about 270 million had been paid on PIM water. And the amounts are in fact set out in 8.7.
Sorry, I don't get that from 8.3.
You can see that 8.3 refers to refers to PIM water.
Oh, yes. Yeah.
And then he sets out the figures in 8.7 and also in 8.9. PIM water closed in December 2017. He doesn't say how many actually received payment, but if one does the math, it's around 270,000, and that's confirmed, I think, in one of his latest reports, Defendants number 2, paragraph 62. I don't think we need to. Well, we don't need to go to that. It's in the next tab at page 3660. So it follows from this that yes, and right, and if you go back to, forgive me, 9.33a, you will see the figure for how many obtained compensation under PIM general, which was about 9,421 families, corresponding to approximately 32,028, which is obviously a much smaller figure than the 270,000 that obtained compensation in respect of water. So it follows from this that the vast majority of the 100,000 English claimants who have accepted payments from Renova have simply accepted payments under PIM water of less than £200. But what is more, they were required to sign releases in return for such payments. There's a sample release which is exhibited by Mr. De Freitas. Which is a Q93. Q93, and if you look at the beginning of the document, it's called a conciliation instrument, program for mediated indemnification of PIM. And you can see the purpose of the document summarized in clause 1 at the top of page 4327. So specifically in relation to damage related to water supply and distribution in that particular city. as a result of the event, and you will see that clause 2 identifies the amount of the payment of 1,000 AIs, and then clause 4 is a release in favour of Samarco, Vale and BHP Brazil, and respective insurance companies, governmental entities, and any other signatories of the TTAC. And so that release extends to any damage as at that date, apart from future damage, which is accepted in clause 1.
Well, damage,
After-
it's damage from interruption to water supply and
Yes.
distribution.
Yes,
It's damage related to the matters specified in clause
exactly. So in this particular instance, therefore, I think the date of this document is December 2017. The amount of the compensation was capped at effectively half of the minimum of the 2,000 that was later set by the IRDR.
And what's the point from this wording?
Well, the particular point here is that insofar as this document seeks to cap the liability of Samarco, you can forget about Vale and BHP Brazil, that is a limitation that does not arise in relation to, for example, a claim against the respondents.
Is that? I expect that's right. We looked at.
So it's an advantage, you say, an advantage in England,
Yes.
in English proceedings.
This is
Well,
an
what was
early form of
novel
release that Renova, forgive me.
We were looking at the novel system once before, which had a wider waiver in favour.
Yeah, the novel form of release came later.
Yes, I see.
This is an early one that Renova was operating in this particular city.
Was there an equivalent for in general or not? Presumably not.
I don't know if there was a similar one for in general. I don't think that if there is, it's been exhibited. But Mr. Suarez gives evidence to the circumstances in which essentially Renova staff were seeking to put the offer, as it were, to impacted victims in return for the execution of the release. I don't think I'll take you to that. I'll just.
The release is also limited to damage related to water supply and distribution, as my lord has said.
Yes.
Yep.
So it seeks to cap material and moral damages in relation to water supply interruption, essentially, as against those three parties, and in particular Samarco. Now, one of the points that that Mr. Gibson made in his oral submissions earlier this week is that there is no individualized assessment in English group actions. And of course, he's right in the strict sense, because the English court will not proceed to have 202,000 individual trials of these claims. But obviously, the English court will deploy its considerable case management powers in order to produce as individualized an assessment as reasonably and proportionately possible in the circumstances, with the assistance of the parties. That, in our respectful submission, is far more than any Brazilian court can do, and much more efficient than having 202,000 claimants pursue their individual claims in local small claims and state courts. Mr. Gibson pointed to the possibility of collective liquidation proceedings in Brazil, but I think we need to be very clear that the collective liquidation proceedings that Professor Didier discusses would follow a generic sentence at the end of the trial of a CPA. That's Didier 1, paragraph 230, bundle H, tab 27, page 1342. They're not proceedings that could be brought now with the avoidance of any doubt. Moreover, Rosa 1, paragraphs 164 and 516.1 explain that such collective liquidation proceedings are very rare in practice and are not practicable in complex cases where the losses suffered by the affected persons comprise different types of loss which are not easily quantifiable. And he explains that during his entire career, and I think he explains his career as a public prosecutor in paragraphs 1 to 19 of his statement, he has never seen a case of collective liquidation and enforcement in an environmental case. Dr. Jeannot, who also has long experience in this field, agrees at paragraph 91, stating that in consumer cases, it is occasionally possible for there to be collective proceedings. But he agrees with Professor Rosa that this is hardly ever possible in environmental cases. Instead, each affected person must usually bring separate liquidation proceedings following a generic sentence, which they may do in their local court. Didier 2, paragraph 52, in response, accepts that the normal position is that affected persons liquidate the award individually. Although he says that collective liquidation is an option depending upon the circumstances of the case. But he does not suggest that he has himself ever experienced collective liquidation proceedings in an environmental case. So there's no real comparison in our submission between the purely theoretical collective liquidation proceedings adverted to by Professor Didier and the group action procedures and case management techniques available in the English proceedings. Mr. Gibson also relied on Professor Didier's reference to the possibility of national judicial cooperation pursuant to Article 69 of the CPC. But Professor Rosa disputes the relevance of this because he considers that that provision is concerned with judicial cooperation in relation to procedural acts and would not therefore permit a shift of jurisdiction to any form of centralized court in relation to decisions on substantive issues. And that's Didier 2, paragraph 311, paragraph B. Forgive me, that at Didier 2, paragraph 311b, he disagrees. But what is clear is that there has been no evidence in the 6.5 years since the collapse of any judicial cooperation pursuant to Article 69. I just want to show you a few more points in relation to the 30th of October 2021 judgment in the novel, in relation to the novel system. So this is in bundle P, tab 79. Page 3766.
So I'm confusing myself. We've just recently had Mr. Gibson's route map to this one. Was it the one we always had a route map to?
This is the new route map, isn't it?
Sorry?
This is the new route map.
Yes, that's right. There is a. I'm very happy to use this.
Yes, I'm afraid I've not myself had a chance to look at the route.
No, fair enough.
It's not there.
So,
it's somewhere else.
It's in queue, I think.
Right.
I didn't know we got the route map, but it's gone into queue.
I thought I'd seen it in Q. Perhaps we have to just identify.
I think it's Q95.
Yes.
But we can have a quick look at it. Because
Well,
it's
simply it's unfair. If you've done your notes by reference to the full document, I don't think we should ask you to use the route map. But I did notice it was there, and as I said yesterday, I find it useful with these very long decisions to understand their structure. But forget it, we'll just note it's there.
Yes, well, I can see it doesn't have the bit that I wanted to show you.
Well, there you are.
So if you go to page 366, I just want to
Sorry,
3766.
3766.
Well, you can pick up the context on page 3765 at the top of the page, where it says the relevance of the priority axis number 7, registration and indemnity, and then over the page 3766. Where it is confirmed essentially that participation in PIM or novel remains optional and is in the alternative to a victim's choice to claim in the ordinary courts.
Where do you get that? Sorry.
I'm so sorry. So 3766, forgive me, it's fourth paragraph from the top. In this aspect, the affected parties, within the scope of their autonomy of private will, shall adhere to the indemnity program that best meets their wishes and intentions, etc. And you can then see the 4 alternatives.
I seem to remember previously we were told there were 3.
Yes.
See what is the 4th?
The fourth, the one that is added is the second bullet point, local registration and indemnities programs. Occasionally there may be some local settlement program or mediation program that's offered. It could be by town or something like that. There are a few examples of those, and I think the judge was simply identifying that as well. I'm not aware that, it's not necessarily clear to me whether it is also under the Renova umbrella, but it may be that it is. I'm only aware of PIM and novel, but it does appear that between the 1st of July 2020, when he gave his Baisho Guandu judgment, and the 30th of October 2021, there may have been some developments on the ground and perhaps some further option was available. But obviously from the point that I seek to draw to your attention is that notwithstanding the choice, as it were, obviously one of the choices was commencing ordinary court proceedings. And you will see that at the top of page 3774, bottom of 3774, he addresses the closing date of completion of registration. And if I can ask you to read the top 3 paragraphs on page 3775.
So this is the closing date for PIM.
PIM, that's PIM general. Yeah.
Sorry, just having these points drawn to our attention, it's helpful to know why they're being drawn to our attention.
Well, I'm just showing you the limitations in, obviously, the various means of redress that Mr. Gibson relies upon as justifying a conclusion of abuse. Up until what is said here by the judge is that the Renova PIM program had been paralysed since January 2018.
That's yes, I think.
And that
And they've been given 2 years to formalise registration.
yes. And that it would be definitively closed in terms of a request for registration by the 31st of December 2021. One of the features that the judge determined in relation to novel appears on page 3809.
Well, can I just understand how this registration works? This isn't, as it were, an extension of the time for the benefit of those who want to apply. This is an extension of time following criticism of Renova in having failed to complete the registration. So does PIM General work on the basis that Renova have to go out and find the people and register them? Or is this that lots of people had tried to register and there was simply a bureaucratic delay, very substantial, in actually registering them?
I think it's the latter, that the registration process, as I understand it, takes some time, and the impacted persons would take the first step, which might, for example, consist of ringing a number or first step.
Yes, I'd rather assume someone has to apply, and so this is a criticism of just the bureaucratic process in terms of registering those who have applied. Is it?
Yeah.
Yes, rather oddly, I might think at a first reading that formalisation refers to what Renova have to do, but I think formalising the registration request manifestation means applying, and then completing the registration is what Renova has to do.
Yes.
Yeah.
Thank you.
And you can see that further down the page, 3775, the judge lays down a more specific schedule for essentially finalising registration requests from different dates, basically. The Brazilian companies have appealed the 30th of October judgment.
Sorry, was there a point on 3809?
I'm so sorry, yes. There is a point on 3809, which is that and it appears in the top two paragraphs on page 3809.
Well, shall we just read them?
Yes, please.
Well, again, I'm sorry, these points are obvious to you. They're not obvious to me. What do we get out of that?
So what you get out of that is that basically there's a cut-off date for applying compensations with the novel system of 30th of April 2022.
Extendable, though.
Extendable if necessary, yes.
So what's again? So what? So what do we get out of that, Mr.
Nobody
thought it would stay open forever.
Yes, it does. Whether it stays open forever, one has to see. But
no, sorry. We're at cross purposes. You are showing us, I think, you're trying to point out that the novel procedure had a cut-off.
Yeah.
To which I was saying, where does that get us? Nobody can have thought it would be open for years.
No.
So what's the point of showing us that a cut-off?
The point is, obviously, there are certain limitations in relation to novel that obviously could create difficulties for the claimants. For example, if they were relegated or confined to claiming through novel. I'm going to come on to some additional points. And I just wanted to remind you of the various aspects of novel that the companies themselves are challenging on appeal.
Well, that's a different point. You are coming to the appeal now.
Yeah, so I'll come on to the appeal. I just wanted to show you what had been decided in relation to the
Yes, I see. Okay, thank you.
The 30th of April.
I'm sorry to hold you up. Just going back to 3775, which is PIM general, is the effect of this that the applicants will have to formalise their registrations by the 31st of December 2021, and so far as processing is concerned, by registration, completing the registration, which is the Renova task, the penultimate one is, if it's in the year before this, they've got until June 2023 to do it, and for those who get in by the cut-off date of 31st December 2021, Renova haven't got to complete the registration until January 2024.
Yes.
Are you making the point that there's scope for considerable continuing delay in relation to PIM general? Is that the point you're making?
Well, yes. There's the cut-off date point, as well as the extended timetable for completing the formalisation of the registration process.
Thank you.
It doesn't apply to the English.
You have to be careful with these terms, that they're not used always quite in the sense we would understand them. Registration literally means registration. It means what we would mean by registration. It means that they'll start to consider your case after registration. Is that it? Registration doesn't mean substantive consideration.
No. Registration seems to be a reference to the beginning of the process.
Yeah, well, that's normally what one would understand, but I just wanted to be quite clear, because the periods do seem quite long.
Yes.
I do apologise, but De Freitas 324 does explain the position for the English claimants who are not susceptible. They are treated. They can register and join the scheme at the moment at any date. They're not subjected to the cut-off date of the 31st of December.
Well, yes, I mean, that certainly is what Mr. De Freitas says in paragraph 24 of De Freitas 3, but the position is not as clear-cut as that when one looks at the documents. And I'll show you some documents in relation to that.
I get the impression that this actually, 3775, isn't setting the cut-off date of 31st December 2021. It looks as if it's a pre-existing cut-off date. And what this is doing is saying how long Renova has to register people depending by when they put in their request. I could be wrong, but that's how it reads. So the first three categories will already have done so by the date of this judgment, and depending how well,
Yes, well, Mr. De Freitas himself treats it as a cut-off date.
Yeah, I'm sure, but I'm just not sure that it comes from this document.
Well, I think both sides have read it in that way. I'm not sure.
Well, all right. I don't want to make difficulties, but we've been shown this in a rather sort of scattergun way. If it's important, I just want to understand how we get there.
Yeah, I understand.
But De Freitas says English claimants will continue to be able to claim through PIM as they have filed their claims in the UK before the 30th of April 2020.
That was Mariana's point.
Yes, that's his evidence, but there's some conflicting evidence in relation to that issue. Let's put it that way.
No.
Because a response is there to De Freitas 3.
There's no response, but when you look at the documents, it's the position is not as clear cut. But can I come back to that in a moment, if I may? I just want to show you the finish with the June, the 30th of October document first, the judgment, If you look at Calafillo next, which is in bundle N, tab 48.
Sorry, just I think I've answered my question. I think the 31st of December doesn't come from the passage you've shown us, but comes from the previous page, 3774 in the middle. He says that there's been plenty of time. I must now set a deadline, and it will be the 31st of December. It's just by the whole bunch. Right. Sorry, where were you taking us to?
Yes. Yes. Thank you. So I was taking you to Calafillo, which is bundle N, tab 48. So you will see that at subparagraph 3, the Calafillo identifies various respects in which the companies, although they support the expansion of the novel system, have also filed a number of appeals against various aspects.
This is paragraph 27, is it?
Paragraph 27, subparagraph 3, yeah. Page 2927. And so you will see there the various aspects that are in issue: A, B, C, D, and E. There is a reference. There is no. There was no exhibit of the appeal, company's appeals, but we've got that now in bundle. Forgive me. There's one point that I wanted to make briefly before I go back to the. I introduce the appeal. What you will find, what you will not find in the 30th of October judgment of Judge Mario is any statement that confirms what Mr. De Freitas says at paragraph 24 of his third statement, i.e. that if, in relation to English claims, if they've been filed before the 30th of April 2020, that they will be treated as covered by the PIM programme. You won't find that statement in the judgment of the 30th of October 2021. And what as Lord Justice Underhill pointed out, the passage that you see at page 3774 is exactly what it says there, and that's it. We're not aware, therefore, of any source for what Mr. De Freitas says in relation to the PIM programme.
Sorry, just remind me where De Freitas says it. I've got it in front of me, but I didn't look it up over it.
It's 294, it's tab 49.
Yeah, I have the statement, I don't have the paragraph.
It's at the top of 2945. Yeah, paragraph 24. Is that what you're referring to?
Yes, exactly. It's De Freitas 3.
And also, it was in the evidence below as well.
Yes, he did make a
Sorry,
statement.
did you say paragraph 28?
No.
Paragraph 24 at tab.
Oh, sorry.
De Freitas number 4.
Yeah, I have it now, I'm so sorry. My fault entirely.
So this is what he says in De Freitas 3, and what he had said in De Freitas 1 a few months earlier, which is in bundle P, tab 77. At page 3592.
Yep.
You will see that in line 4, he says, even if the registration program does close, Renova has proposed that individuals who have pending lawsuits in respect of damage suffered as a result of failure of the dam will still be able to receive indemnification.
Sorry, it must be Friday afternoon. 3594.
2.
3592,
Yes, but where?
paragraph 9.34.
Yes.
So he says Renova's proposed it, but it was never formalised or ratified, as far as we know, as part of a decision of the 12th Federal Court.
Did it need to be? Renova is master of his own procedures and that's challenged by the parties.
Well,
But who would challenge
the judges? The judges closed it.
Oh, I see what you mean. Yes, of course. No, but hang on. By the time the judge closed it, the claimants had, if this is right, got over the hurdle. The English claimants.
But they haven't registered. Or hadn't tried to either. They hadn't taken any steps to.
Your point is, this was what was being proposed, but
Yes.
when it came to it, what Judge Mario said is everybody's got to get in by the 31st of December.
Yes.
And the claimant...
He's not treating.
There's nothing in the judgment that says just because you've got a foreign claim in that'll count.
Exactly.
And therefore,
Yeah.
some of the claimants may no longer have PIM general available to them. That's what you're
Thank you.
submitting.
Yes.
Well, this is a completely new point. Never been questioned.
Well, I agree. I'm not sure it
opened-
arises in reply, does it? But well, let's see where we are when we get to the end.
The carve-out has not been disputed before in this case, so far as I know.
We hear what you're saying.
Thank you.
Well, the documents speak for themselves. Is a short point, and the evidence is before you, and you can draw your own conclusions. And I was going to show you the appeal document in relation to the 30th of October 2021 judgment. Q96, which I think may be at Q96. I showed you earlier the various respects in which the company is, as described by Mr. Calafillo, is challenging the 30th of October 2021 judgment.
Yes, I think it might be sensible to have that open at the same time.
So if I can ask you to look at paragraph 88 of that document.
Paragraph 88 of what?
Of the appeal document. Of
Page 4373.
But I don't have a paginated version, but I'll...
4373.
4373, thank you. So essentially, the company, as described in paragraph 88, is seeking to limit the extension of the closing date to 30th of April 2022 to a few municipalities and not to all areas covered by the local commissions. You can see a list of the so-called remaining municipalities, as referred to, defined in paragraph 69.
Sorry, just tell me why we're doing this. We've got Mr. Calouf's explanation of the areas in which it's appealing, with some explanations in the footnotes. Are you saying that's inaccurate, and you're asking us to
Well, he doesn't really explain this aspect of it, which is that the company is in fact seeking to limit the area of operation of the judgment, insofar as the judgment extends the date.
He does.
Well, isn't that what footnote 18 says? Or am I?
Well,
No. Oh, no, I see. No, that's no, it isn't what footnote.
I'm quite
18
sure it's the
says.
same point.
It's 27. 27.3.
It is. I mean, it's entirely up to you, Mr. Chucho. I mean, you've got how you use your time. This is, I had thought what Mr. Calouf said at 27.3 was a reasonable summary, but of course I hadn't compared it against the appeal document. But if you want to show it's inaccurate and understates the extent of their appeal, of course, then you must do that. But I think the point you're making is covered by footnote 21, isn't it? But anyway.
In terms of the scope of those to whom the novel system has been rolled out, which is subparagraph A of Calafilo, the expansion of the novel system to new areas beyond those identified in TTAC, the challenge is it to whether the novel system should be allowed to be available to those who are at the top of page 4369, the remaining municipalities. Is that where we find in the underlying document?
Yes.
The areas which were said to be excluded from TTAC and therefore for which the companies are contending that the novel system should not extend.
If it assists, it's footnote 13 of Caliph, where he makes it clear that this includes 99.2% of the English claimants who say they live in areas defined in the TTAC. So the challenge could affect point 8.
So sorry, which footnote?
It's footnote 13 on page 2925, footnote to paragraph 25, which makes the point that the expansion includes 99.2% of the English claimants who say they live in areas defined in the TTAC, which the companies do not contest should be included in the novel system. So the point my learned friend is on relates to the remaining 0.8%.
I think that's a different point.
He's on the timing point. I'm so
It's a
sorry.
timing point.
I do apologize.
I wasn't on the timing point, so you were right to try and help me with it.
So, sorry, Mr. George, I don't want to bang away at you.
Yep.
I'm not quite sure what we're doing. What are we doing here?
Yeah. Well, I just want to make sure that the court is aware of certain limitations and risks, as it were.
Yeah, you're running through a list of limitations and risks by reference to the matters relied upon by Mr. Gibson.
Yes.
Yeah.
Yeah. I mean, I
No, I understood that, but what are we doing by going to the... are you saying that Mr. Calafilo's thing is wrong, or that it doesn't quite give the whole picture?
Well, I just
or...
wanted to give you a little bit, to give you a bit more detail in relation to one aspect.
Okay, I'll stop. You do it. I'm sure you're right and I'm wrong.
But, I'm conscious of the clock ticking, and I will therefore crack on. Can I just make sure? Can I just give you some references? I appreciate you've probably got more references that you would like. In relation to the question of legal aid and legal representation, I think we've you already have Jeannot 113 to 122, as well as Resec 2, paragraphs 98 to 111. May I please ask that you also look at the statement of Federal Deputy Batista at paragraph 27, which is in bundle Q, tab 90, pages 4296 to 7. Just a couple of final points of detail before I resume my hopefully rather more fluid flow of submissions. Mr. Gibson relied heavily on paragraphs 132 and 133 and he made a lot of that. The short point I make in relation to those two paragraphs is that if you look very carefully at those, all that they say in relation to Renova is that basically Renova had never refused to provide compensation to anyone which Renova determined should get compensation. So it's basically saying Renova pays when it agrees to pay, and that's it. And so far as the various observations that Mr. Gibson relies upon in between paragraphs 121 to 135 of the judgment, I think he said on a number of occasions that we didn't challenge those findings. We do challenge those findings in ground 5 of our grounds of appeal. I just have one final little topic before I go back to my main submissions. This is on the Samarco JR evidence. I think Mr. Gibson suggested that that evidence was not served in response to paragraph 1B of the respondent's notice, which was dated 30th September, because we had indicated in an earlier skeleton that we intended to rely on the JR evidence very shortly after Samarco filed the petition. But there is, in fact, no inconsistency here, because even before receipt of the respondent's notice, we anticipated that the respondents would want to continue to pursue the full redress argument, and wanted to make sure that we were able to rely on the fresh developments in relation to judicial reorganization, which is why, in the event, the Vice President's order, after permission to appeal was given, contained a special provision for any application by the party to rely on fresh evidence. And thus it is that in October 2021, after their respondent's notice had been filed, we then applied for permission to adduce fresh evidence pursuant to paragraph 3.1 of the Vice President's order of the 23rd of August 2021. I've already addressed you as to why we say that to the extent that it is material to your findings, why you should consider that evidence, because the respondents simply cannot conscionably continue to maintain arguments that proceed on the premise that Samarco is fully capable of meeting any judgment against it without taking account of that evidence. May I summarise, therefore, my submissions on the pointless and wasteful litigation? There can be no case of pointless and wasteful litigation by reference to the availability of the Renova programmes of redress, whether PIM or novel. First and foremost, because those programmes are entirely consensual and themselves expressly contemplate the possibility of ordinary court claims for any victim who does not wish to avail itself of the programmes. Mr. Gibson has failed to address in his submissions the significance of the consensual nature of PIM and novel, and of the express permissibility of court claims in the alternative. He has repeatedly observed during his submissions that if any claimant is not satisfied with PIM or novel, it can bring an ordinary court claim. It is implicit in that observation that it would not be abusive for the claimants to bring court claims instead of claiming under either PIM or novel. There may be jurisdictional questions as to whether such court claims, as to where such court claims should be brought, but that is not a question of abusive process. Secondly, there is no evidence before the court and no finding by the judge that all or any of the claimants would clearly and obviously recover more under either PIM or novel compared to what they could recover in England, even after taking account of the contingency fee payable to their solicitors and funders. And for completeness, you may wish to note that even under the novel system, applicants' lawyers are paid a contingency fee of 10% of the amount paid by Renova. And this is Bundle P, tab 79, page 3738 and 3740. You want to look at it very briefly?
Yes, please. First time for myself, anyway, I've heard about that.
So if you look at 3738, paragraph 3, at the bottom of the page.
The limited to 10%.
Yes. And then if you look at 3740, you can see under the heading attorney's fees, at least in this particular example, I hereby state that I am aware and agree to 10% of the total amount, etc.
This was before the judge, was it?
Yes, as I understand it, these are all in one or another sort of ratified by.
No, they were
I'm
before
sorry.
Mr. Justice Turner because it's an exhibit December 21.
I'm not aware of this being before Mr. Justice Turner. It's part of it's been exhibited by Mr. Calafillo after the judgment.
It was in its infancy, really, by the time he got to consider it.
Yeah, the bike show judgment has only just come out, so yeah. The third point is that although this aspect does not matter in my respectful submission in the light of my earlier 2 points, it is nevertheless worth noting the following unsatisfactory and uncertain features of PIM and novel. First, the amounts of compensation paid by Renova through PIM, at least so far as the claimants were concerned, were relatively modest and generally restricted to moral damages for water supply interruption. This had been the position as at the date of the hearing before the judge nearly 5 years after the collapse, and the seminal judgment in the Baikshore Gwandu LC proceedings opening the way for the novel system only came out a week before the hearing. As recently as last October, as you saw in the 30th of October judgment, Judge Mario himself described the PIM registration program as being paralysed. Whilst the novel system is clearly a laudable effort by Judge Mario, it would not necessarily apply to all of the claimants. Each local commission decision recognises specific categories of person. For example, the list of categories of persons in the Baikshore Gwandu judgment at G22, pages 1047 to 8. You may want to have a quick look at that. You will probably recall how he identifies the list of fishermen, the washerwomen, and so on and so forth. And there's maybe a list of 12.
Are you able to indicate any categories of individuals who are not covered by it?
No, I don't think there is such a list, but...
No, are you... sorry, I may have misunderstood your point. Was your point it's not clear that it covers everyone, that it's confined to certain categories?
Yes.
I was just wondering whether there are any claimants who didn't fall within those categories.
There are several claimants who don't fall in any of those categories.
Well, are there any types of claimant who don't fall within those?
So, for example, someone who has a beauty salon, let's say, you won't see a beauty salon person
I get
in
it.
that list, and it could be a number. It's particularly the case for businesses which don't easily fit into any of these categories. And I'm not saying that I have a
No, you've given me an example. I just wanted to see what sort of point you were making. That's fine, thank you.
So on any view, it doesn't apply to large businesses, and even if you're a small business and they're technically within, you may be excluded.
You may be excluded because the rough justice regime.
There's a matrix. There isn't just a matrix figure for you. Yeah.
Exactly.
Yeah. No, that's helpful.
Yeah. No case of pointless and wasteful, and obviously, as regards the novel system, as you know, whatever its merits and future as a system of rough justice, again, the simple fact of the matter remains that it's not mandatory. No case of pointless and wasteful litigation can be made out by reference to the acknowledgement of an obligation to provide full redress by Samarco and Renova. As to Samarco, we are rather sceptical as to precisely what Samarco is agreeing to by its generic acknowledgement of an obligation to provide full redress in circumstances where it has formally refused to admit any liability in the formal documents that it has executed, and denied liability in several of its formal defences in Brazil. Its formal position, as recorded in clause 256 of the TTAC, you will recall, but it's also denied liability on various grounds in both the 20 billion CPA and the 155 billion CPA. And I'll just give you some references, including the respondents' references. In relation to the 20 billion CPA, Vivan 1, paragraph 69 to 74, and De Luigi 1, paragraphs 126 to 127. And as regards the 155 CPA, Vivan 1, 185 to 191, and De Luigi 1, paragraph 217. It has also denied liability in numerous other cases in Brazil, and several examples of those appear in Appendix 20 to our first instance skeleton, which is in Bundle D, tab 13, pages 487 to 488.
Has it admitted liability anywhere?
I'm sure that there may be some, there will be some cases where it has, but it's certainly not uniform, if I can put it that way.
Did Judge Mario's July 2020 judgment grant relief formally declaring it had liability? Isn't that one of the... If I misread that.
I don't think he declared liability per se, but he did make a comment in the context of an argument about costs, that he was treating the proceedings before him as an ordinary court action, and that the obligation of full redress had been, he was treating that as being established.
Okay,
Which you will find that passage, in fact, I think it's in the last box of the claim of the respondent's summary of the Baixo Guandu judgment, the one that the Vice President finds useful, which we all find useful. I think it's Appendix 4, something like that, to the respondent's skeleton. But Samarco's position, in short, has never been that whenever it's been sued, that it goes straight to quantum. Its position has always been more nuanced than that, and you get a sense of that when you read the passages that have drawn to your attention. But even if we put our skepticism to one side, and Samarco's and we treat them as having made sort of standing, open-ended admission of liability. That does not, in my respectful submission, deprive the English claims of tangible benefit or make them abusive. First, as we know, Samarco has made it clear, somewhat late, but has made it clear that it does not acknowledge any obligation to provide full redress in respect of the 13 of the larger businesses. That's Michael 5, that's respondent's skeleton, paragraph 1 to 120. This inevitably means that a trial of liability would be necessary even against Samarco. I don't recall Mr. Gibson suggesting that the claimants would find it easier to prove liability against Samarco in the case of the 13 large businesses than to prove liability against the respondents in the case of all of the claimants. But in any event, this would be an impossible calculation to make at this stage of the proceedings. Any attempt to do so would clearly cross the line between what the court may legitimately consider in order to ensure that its process is not misused and what should be left to the commercial judgment of the claimants and their advisors. Secondly, as regards causation and quantum issues, there is obvious benefit to the claimants proceeding against the respondents in England, given that they can take advantage of the English court's English courts extensive powers of case management in group actions. Whereas in Brazil, they would essentially have to bring a huge number of individual actions in their local courts, the inevitable effect of which will be to create huge delay and backlog in the resolution of their claims, as well as give rise to a considerable risk of inconsistent judgments. Thirdly, depending upon the claimant's assessment of the strength of the merits against the respondents, the advantages of English proceedings over Brazilian proceedings with respect to the causation and quantum aspects are such that they could still make English proceedings more advantageous overall compared to the Brazilian proceedings, even if liability was not an issue as against Samarco in the Brazilian proceedings. Again, this is the kind of assessment that is best left to the commercial and legal judgment of the claimants and their advisors. Fourthly, having to bring a multitude of individual claims in local courts would also mean that the claimants lose the benefit of the well-funded and well-resourced specialist legal team that they've been able to secure in England. In that event, the great majority of the claimants would be left struggling to secure adequate legal representation for their respective claim. Fifthly, at an individual claimant level, looking at matters on a claimant-by-claimant basis, the personal circumstances of many of them may be such that for them to bring their own proceedings against Samarco is not something that they would want personally to engage in or realistically can engage in. Giving access to such claimants through the kind of funding arrangement that is capable of being set up in the context of the English proceedings is obviously a legitimate exercise, and it can't possibly be abusive for such claimants to prefer to let their claims be made for them against the respondents in this way. Sixthly, in the light of the judicial reorganization of Samarco, there are serious doubts as to, first, what proportion of Samarco's dam-related liabilities will be treated as recoverable as part of the judicial reorganization. You may recall that Samarco's creditors assert that Samarco should bear no more than a third of the liabilities, with Vale and BHP Brazil bearing a third each. This is obviously a fundamental issue that goes to how Samarco's assets, as part of the judicial reorganization, can be shared out. There are also serious doubts as to whether Samarco's dam-related liabilities will be treated in the judicial reorganization as being pre-bankruptcy credits, and therefore subject to the judicial reorganization. The uncertainties created by the JR on their own justify the claimants in seeking redress against the respondents. Seventhly, a claim against the respondents may well produce a better settlement than a claim against Samarco, especially in circumstances where the respondents may well have a powerful incentive to settle and avoid a public investigation at trial into the precise role and knowledge of the respondent's senior management and executives with respect to the risks of collapse. That is an entirely legitimate litigation objective if the claims are entirely viable. Eighthly, having regard to the nature of the pleaded claims, the respondents are the natural defendants anyhow, because they are the ones who are alleged to have directed the policies that led to the collapse. Why should claims in respect of such conduct be shunted to some non-profit foundation that they've chosen to establish for their own purposes, PR or otherwise? Why should they not be held accountable pursuant to entirely arguable claims?
Are these points that were in your skeleton argument?
Well, quite a few of them. necessarily all of them, but
Okay, I'm a bit reluctant to see reply used for. I hadn't spot one or two of these. I may just not have been listening carefully enough. One or two of these justifications hadn't really been developed, I don't think, but perhaps I missed them.
well, I mean, we were under a limit of 75 pages, so it's not as if every point
Okay,
I
what's
make
your eighth point?
well, I think I'll stop at 8. I'll move on to Renova. But seriously, we do have a number of paragraphs in our skeleton argument where we make the general point that litigation considerations, tactical, strategic considerations, and things of that kind, those are matters that are really for the claimants or the litigant and their lawyers, not for the court or for the opponent to dictate. As to Renova, as I have previously submitted, there is no credible basis for the proposition that the claimants have a direct cause of action against Renova. Nothing in Mr. Gibson's submissions gave any indication of how the claimants had acquired any cause of action against Renova. Even insofar as Renova may be said to owe an obligation to provide full redress under the TTAC and the GTAC, that obligation would merely be an obligation to provide redress through the programs that Renova manages under the TTAC and GTAC. Since those programs are optional, it follows that Renova could be said to owe the claimants an obligation if and to the extent that the claimants elect to claim under the Renova programs, which of course is different from an ordinary court claim. The series of statements made by Mr. De Freitas in his third witness statement, paragraphs 12 to 17, have to be taken with somewhat of a pinch of salt, because they're completely at variance with what Mr. De Freitas said shortly before the first instance hearing. And you probably ought to look at that very briefly. And this is De Freitas number 2, paragraph 14b, bundle P, tab 78. So whilst you may recall that in De Freitas 3, he essentially said, well, Renova will do anything, will pay, will admit everything, will pay Samarco's judgments, etc. If you look at what he was saying about what Renova would do at paragraph 14b on page 3633, that was quite different.
Well, this is the first time this point has been made as well, with respect. So sorry. This is the first time this point has been made in reply.
Well, the court can see the evidence of Mr. De Freitas for what it is.
Of course, some latitude must be given, but it does puts Mr. Gibson in a difficult position. But it also puts us in a difficult position if new points about the evidence are introduced, which at the moment I don't understand to be by way of rebuttal of points made by Mr. Gibson.
Well, Mr. Gibson heavily relied on paragraphs 12 to 17 because he said it doesn't really matter what the position is vis-a-vis Samarco, or that Samarco may be under a cloud because of the JR, because he says Renova will step in and satisfy any judgments against Samarco. That's a central feature of his case as to why, therefore, we're just wasting our time here. And we should be in Brazil because we should pursue.
Well, I think that was part of his case before you got up first time. But anyway, I'm not going to stop you. These cases are difficult. All sorts. This case in particular bristles with little points, and I do understand that I say little points. I mean points of detail of this sort. I do understand that you can't anticipate all of them first time round. But if Mr. Gibson is put in real difficulty, we may have to give him an opportunity just to say what his answers to some of these points are if they're completely new.
I certainly would not have.
Okay, well, keep going. So you were taking us to...
just paragraph 14b.
Yeah.
You can see there that the acknowledgement and confirmation of the obligation to make full redress was firmly anchored to the TTAC and the GTAC, and then you can see all the other qualifications that he identifies. Insofar as Renova is now purporting gratuitously to assume a unilateral obligation to pay Samarco's judgments, there is, of course, no, as I think was accepted by Mr. Gibson in exchanges with the court. There is no Brazilian law evidence to confirm that such statements are properly authorized on behalf of and within the capacity of Renova. And of course the onus here is on the respondents as the ones who are seeking to suggest that this entire litigation is pointless and wasteful, to show that that is so, or that such statements are in any way legally binding and effective as a matter of Brazilian law. All we have is very generally worded statements in a witness statement. What is more, it is wholly uncertain how Renova would fund the payment of Samarco's judgments, since Samarco's and its shareholders' funding obligations under the TTAC, clauses 225 and 237, are only in respect of funding Renova to maintain its programs, not to pay Samarco's debts, pursuant to ordinary court claims. And I think Mr. De Freitas says in his, and I think Mr. Gibson relied on that as evidence as providing reassurance as to what would happen in the future. He says, well, look at what's happened so far. And I think Mr. De Freitas says at paragraph, this is bundle N, tab 49, page 2941. Paragraph 11, bottom of the page, it says that as of the 3rd of December 2021, Renova has already paid about 36.4 million, about 5.8 million pounds on my calculation, in individual indemnification due to settlements entered by or judgments rendered against Samarco. And of course, the fact that Renova has to date paid that kind of money says nothing at all as to Renova's legal entitlement to secure all of the funding that it would need to meet judgments against Samarco. But further still, the statements made by Mr. De Freitas don't really assist the respondents, because there is nothing unreasonable or abusive in the claimants preferring to sue the respondents in England rather than to sue Samarco in Brazil. And insofar as the gratuitous commitment has been given to alleviate any problems that may be caused by the Samarco JR, the proposal doesn't work anyhow, because it fails to deal with the fact that the uncertainty in the JR relates to how Samarco's dam-related liabilities should be dealt with in the bankruptcy, and in particular, whether those liabilities are to be capped at a third and treated as an unsecured pre-bankruptcy credit in competition with all other unsecured pre-bankruptcy credits. It also overlooks the fact that under Samarco's JR plan, Renova's funding for the next $2.4 billion in the 10th of March plan, that Renova's own funding is to come from Samarco out of its cash flow. Numerical clause 5.3.
Sorry, 5.3, clause 5.3
Of the 10th of March plan, which is in bundle, should be in bundle N, tab 50. Forgive me.
I don't remember reading that.
Well, we can see the clause in there.
So where are we?
So if you look at the forgive me, if you look at the slightly earlier version of the plan, it's clause 5.2.
No, sorry, I need a bundle
3007. Forgive me.
page.
3007.
3007.
Yeah.
Sorry, you'll have to just help me. There's been a lot of material here. The 3007 we've seen before. So I've got a tab in it.
So it's tab 50, page 3007, clause 5.8.
Yes.
And you can see that the Samarco, as the party that funds Renova, according to the plan, this is Samarco's own proposal, that Samarco will comply with the obligations of financial contribution to Renova Foundation from the date of ratification of the plan according to its cash availability, up to the total amount and limited to 2.4 billion. So the first, or the next $2.4 billion that is to fund Renova is to come from Samarco itself. So the only point I'm making is that
What does the phrase "according to its cash liability" mean?
well, according to its own cash flow, according to its own cash availability, is a reference to the fact that the company is back to 25% or 26% capacity and does generate some cash flow, some business. It's not back to full capacity, but it is generating some revenue. And
It doesn't mean provided it has.
I think it does. You're right. Either way, you've got a
well,
point.
yeah,
And
yes.
the point
in a
is,
way, it doesn't particularly matter where it gets the
No,
cash
quite.
from. It certainly doesn't get the cash from Renova because it's the one that funds Renova, or in default, the shareholders do. But I'm simply making the point that it's difficult to understand the proposal or a statement that Renova will pay Samarco's judgments if Samarco itself can't pay, when one of the central features of the JR, because the company owes $11 billion to its creditors, is that it will be using its own funds for the first 2.4 billion to fund Renova.
I've just gone blank. Where's the statement referred to by Mr. Gibson that Renova will pay Samarco's judgments? That's in a De Freitas statement.
That's De Freitas.
Okay, I'll find it. It's fine.
Freitas.
Defendants 3,
Is it?
11.
I don't see it.
page 2942,
What paragraph?
15.
15.
paragraph 15.
Thank you.
So this contradiction, essentially, or putting it
I see.
slightly more neutrally, this uncertainty is neither identified nor addressed in Mr. De Freitas' evidence. So for all of these reasons, we respectfully invite the court to reject the notion that the claimants should be confined to suing Samarco, or still less Renova.
It's paragraph 10, actually.
So that takes me to Article 34.
Yes, paragraph 9, clause 237 of TTAC requires Samarco's shareholders to fully fund Renova if Samarco is unable to do so. If you carry on the chain, says Mr. Gibson, you get BHP Brazil and Vale.
You don't, because 237 is about the funding of Renova's obligations under the TTAC and the GTAC. That's what it's about. It's the programs under. It's not the ordinary court liabilities that Samarco may incur. That's got nothing to do with the TTAC or the Renova programs. That's something that is outside the programs.
I'm sorry, I'm being slow. I'm sure everyone else is there. Why doesn't? Explain again why the fallback obligation on the companies doesn't apply, on the parent companies doesn't apply.
Because the fallback obligation applies in respect of Samarco's funding obligation under the TTAC and the GTAC. That obligation has got nothing to do with the liabilities that Samarco may be held to have to victims as a result of court proceedings.
A direct action against Samarco.
Exactly.
Judgment on a separate lawsuit.
Yes.
I see.
Yes. The Renova programs are here. You can claim under them if you want to, but if you don't, you can.
No, I've got all that.
Yes.
Yes, okay.
You when you look at clauses 2, 3.
Well, look, unless you want to, don't spend any point on this till my doubt about it. I think I do understand.
Yeah, I think it's 231,
My lady
232,
will put me right
237.
if I don't.
So I need to move on to Article 34. I think if we have bundle F of the authorities bundle. Article 34. I just want to take a step back because in my respectful submission, the language of the meaning of expected in 1B and the meaning to be attributed to the words that follow are quite closely interlinked. One of the points that Lord Justice Popplewell made, which I think the Vice President as well took up with me when I was last on my feet in relation to 1B, was the fact that obviously there may be all kinds of judgments that might be capable of being delivered by the third state court. And there could be a summary judgment, there could be an interlocutory judgment of some kind, an injunction, and so on and so forth. And obviously some of those may be capable of recognition, others may not be. If, when you approach Article 34, you take as your starting point the entire range of judgments that a third state court might give, then it's unworkable, it's impossible to apply Article 34 in a meaningful, practical way, unless you actually treat expected as relating to the type of judgment that may be an issue. Because otherwise, what you would be thinking of is a multitude of potential judgments that the third state court might give. And it's virtually impossible to apply the test or to determine whether one be satisfied. So on one approach, therefore, you consider all kinds of judgments that the court could give, but then you could only apply 1B by saying, well, is this or that kind of judgment actually expected, because otherwise you can't apply the section. An alternative approach would be to focus on the fact that the purpose of the section is to prevent or to at least minimize or avoid the risk of irreconcilable judgments, which therefore means you need to focus on the particular type of judgment that might give rise to a risk of irreconcilable judgments. Because after all, that is why you might want to invoke Article 34. If you focus in that way on the risk of irreconcilability as the benchmark, as it were, against which you consider the particular type of judgment that you need to consider, then in our case, there can be no doubt that the particular type of judgment that we're talking about is a CPA judgment. We're not talking about some other hypothetical judgment or dozen other judgments that the Brazilian court might deliver. We're talking about a CPA judgment, because that is the key judgment that is said. It happens obviously also to be the judgment on the merits at the end of the related action. But if you look at it that way, then there's one type of judgment that you're focused on. And the question then is, how do you apply the language of it is expected that the third state court will give a judgment capable of recognition? In other words, will give a judgment of that type capable of recognition. If you approach it in that way, and if you're dealing with a judgment that is asymmetric in its nature, i.e. it is enforceable on one outcome, but it is not enforceable on another outcome, it is impossible, in my respectful submission, to apply the language of it is expected that the third state court will give a judgment capable of recognition unless you conduct an assessment of which way the third state court will go. Because if you're dealing with an asymmetric judgment, you know, ex hypothesi, you know when you're applying 1B, you know that on one scenario, the judgment will not be capable of recognition, but on another, it will be. So logically, in my respectful submission, you can only then come to a conclusion as to whether it is expected to be capable of recognition or not, as the case may be, if you can take a view as to which way it's going to go. Now that can't be right.
simply don't follow that, because you say expected means there is a realistic prospect of, and it's perfectly possible without investigating the merits at all to say there's a realistic prospect of it going one way and there's a realistic prospect of it going the other way.
Well, but if that's the only conclusion that you can draw, that it is a real prospect that can go either way, in my respectful submission, that is also pretty unworkable within 1B, because in a way you're expecting either. You're expecting either that the judgment that the court will give will not be capable of recognition, or that it will be. There's a real problem there. A more logical and clear-cut and conceptually easy and certain approach to this problem would be to treat a judgment of the third state court to be a reference to a judgment, however it's decided. once you've identified the particular type of judgment. There's nothing wrong with that. There's nothing surprising about that, because of course the genus of CPA judgments we're dealing with in our case is obviously a very, very unusual one. Most judgments you would expect either not to be enforceable at all, either way, or enforceable whichever way they are decided. It so happens that we have this very curious type of judgment that works one way but not the other. But there's no reason to suppose, in the context of an article that is meant to apply, not in the context of, as between member states, where essentially all judgments are entitled to automatic recognition, there's no reason to suppose that the underlying policy was a very broad one of applying to as many judgments as possible. There's no reason for that. There's no reason for assuming that's the policy. Because as we know, Article 34 has additional requirements compared to Article 30 through 1B and 1C. But there's a real problem, in my respectful submission, when you're dealing with a judgment of a kind which is enforceable on one outcome but not on the other, because it makes it extremely difficult to implement the expectation test in a sensible way. Because, well, I'm just going to be repeating myself for the reasons we've just discussed. So that in my respectful submission, is a short point. It can't have been intended that the member state court should be trying to guess which way it's going to go, even at a very high level, in my respectful submission, even at the very high, the sort of low, above the low threshold of something that's not fanciful. Because if it's that low, it can go either way. How can you say that it's expected when it's expected either way? Why would it be expected? It can't be simultaneously expected one way, but also the other way. And so that's a real conundrum. But I go further and I say...
That's using expected in the sense of more probable than not.
Well, that's even worse.
No, but that isn't your case.
That's not my...
You say it can't be expected one way and expected the other way, and yet you say what expected means is real prospect, no more than fanciful. I just don't see any difficulty in, if you apply that test, if that is what expected means, in being able to say, well, you can be fulfilled both ways.
Well, I obviously heard what Mr. Toledano said this morning, and I've seen the Travo. I can see the force of the argument that actually expected was directed to the quality of the judgment, particularly if you look at recital 23 as being fairly determinative in what the intention was. What you can't do, in my respectful submission, is, as it were, in a way, one has to be consistent, because you say to me, well, on your construction of expected, well, you're going to have to take a view as to whether my construction of expected is right. If you take the view that it's wrong, there's no point challenging my approach to capable of recognition by reference to a construction that you consider to be wrong. You're going to have to be consistent. I'm perfectly prepared to accept, for this purpose, that there's force in the argument that expected should be seen as going to the quality of the judgment rather than the actual giving of it. I can see that. I don't conceptually have a problem with that. But if that's right, then in my respectful submission, that is a stronger reason why I must be right in relation to the second point. I think my construction in relation to the second point can work anyway, even on my view of expected, because on my view of expected, the expectation would relate to the giving of the judgment. It need not relate to the quality of the judgment, because on my construction, on the second point, I say a judgment means a judgment decided whichever way. And if that's right, then the fact that it may be expected, of course it would always be expected that there'll be a judgment one way or the other.
But if you're wrong about expected,
yes,
then we're really ignoring what that means in terms of what's going to happen. and we get onto the wording capable. And that's the word that governs whether a one-way recognisable judgment does or doesn't qualify. And one's looking at something which is capable of being enforceable or recognised.
But the point being that a CPA judgment is only capable of recognition if it's decided one way.
Yes. So it is capable. It is capable of being
If
recognised
decided one way.
If decided one way.
Yes.
Yeah.
Yes.
Well, that's the argument against you. Yeah.
Well, it's not an argument against me because it's not an argument against me because that's not what the section says. If you were to read, I mean, a good way of testing normally whether one's construction is correct is to set out the language in full in the relevant clause. If you set out in full what you say is the right meaning of the word, you would say it is expected that a judgment of the third state court will be capable of recognition if decided in favour of the victims. That would be the meaning, because there's no other circumstance in the case of a CPA judgment. There's no other circumstance where there would be such a judgment that's capable of recognition. So I do say, therefore, that you can't. What you can't do, in my respectful submission, is effectively posit the circumstance in which it would be capable of recognition, kind of bag it, as it were, and treat it as part of your of the language of 1B, and then say, well, it is capable. That's not the point. It has to be. It is expected that a judgment of the third state court or the third state court will give a judgment capable of recognition. If you just read it on its own, it's not calling for any inquiry as to what the outcome will be. And that makes perfect sense, because it can't have been expected that that would ever be a relevant inquiry, even at a low level of threshold, low merit threshold. I better get on, because otherwise I will run out of time. Just a couple of points in relation to 34.1a that my learned friend made. He says that because we've conceded 34.1a, you have to bear this in mind. Well, our concession in relation to 34.1a is simply a concession that we accept that because of the relatively low threshold for related actions as established in the Tartary and Sario, that yes, the actions are, broadly speaking, related. But the fact that the actions are related does not mean that you don't then look separately at the requirements of 1B and 1C to understand whether they are engaged. All that 1A tells you is that the actions are related. It doesn't tell you anything about the extent of relatedness or anything of the kind. The second point that my learned friend made is that, well, the standard of review ought to be different under 1C, even though, just like 1B, it's a threshold. It may be that not much will turn at the end of the day on that point, but I do want to emphasize that 1C has within it the standards of the court having to be satisfied and it having to be necessary to impose a stay. The notion of necessity does not easily lend itself to the idea of a discretion. It's either necessary or it's not. It's difficult to suppose that there was intended to be a discretion to be as to whether it should be necessary. My learned friend showed you a passage in the Alexandros T that referred to presumption of a stay. I don't think he relied on that specifically, and he didn't suggest there was a presumption in favour of a stay. But let there be no doubt about it, there is no presumption in favour of a stay in the context of Article 34. We dealt with that issue at paragraphs 262 to 273 of our first instance skeleton. So far as the question of degree of likelihood of a judgment on the merits in the 155 CPA is concerned, obviously you will have to consider the evidence from Professor Rosa and Professor Didier in your own time. But one thing that I would like to point out in relation to the GTAC is that when you look carefully at the language, and if you go to tab 19, clause 99, page 1024, you will see that the sole paragraph at the top of page 1025 refers to if the parties reach a partial agreement or are unable to agree to succeed in the renegotiation of the programs. So this is talking about the renegotiation of programs, the extent of agreement or otherwise. The matters in relation to which there is no convergence may be submitted to the 12th Federal Court. This is the context for what then follows in 103 after the main part of Clause 103, which deals with what is to happen to the actions, including the stay of the 155 CPA. When you look at paragraph 1, it says, on the terms of the sole paragraph of section 99. So the context for what is provided in 103 paragraph 1 is the terms of paragraph 99, section 99, the sole paragraph. And so when you look at it in that context, in my respectful submission, the reference to claims made that have not been addressed in the renegotiation process is self-evidently a reference to matters that are appropriate for the renegotiation process and that may either be the subject of agreement or non-agreement or perhaps the subject of omission. But the subject matter of both 99 and 103 as a whole, in my respectful submission, is the subject matter of the renegotiation. And that's, in a sense, reinforced by 103 paragraph 2, where what you see is, more specifically, any disagreement between the parties in relation to compliance. So that's compliance with what's already been agreed is to be referred to the 12th Federal Court. So it's unreal, in my respectful submission, to read 103 paragraph 1, therefore, in that context, as being a reference to an issue, an original, an intrinsic issue of liability on the merits as being the subject of the renegotiations, and therefore as being something that would be remitted for determination by the 12th Federal Court. Not least because, in fact, you might think that if the draftsman was actually referring to the issues that arise inherently in the action, there wouldn't be need for any provision, because if there's no settlement, well, the action's there and then has to be proceeded with. This is specifically concerned with the submission of disputes arising in the context of the renegotiations. And so from that perspective that I ask you to understand Professor Rosa's evidence. But leaving this technical debate to one side, on any view, in my respectful submission, by far the more persuasive evidence in relation to the question of likelihood of the fundamental issue of liability ever becoming the subject of a trial, by far the more persuasive evidence in relation to that is that of Professor Rosa, for the reasons that he gives and that I've touched upon before. And obviously that is the degree of likelihood is highly material to how you exercise the discretion. It's not enough for the respondents to say, well, there could be potentially a reference of the issue of the fundamental issue of liability to the 12th Federal Court, and therefore that effectively engages the discretion to stay and should lead to a stay. That's far too low a hurdle to get over. Mr. Toledano emphasised the point that the MPF seeks the joint and several liability of the three companies in the 155 CPA. Well, that's true, that's its formal claim, but what we also know is that all three companies agreed to the principle of full redress under the GTAC. There's no disagreement of principle on their part that full redress ought to be given, albeit subject to the terms of the TTAC and to be further renegotiated under the GTAC. And so the question, therefore, for you is, in that context, is it really serious? And in the context, obviously, of negotiations having gone on now for probably 5 years or not far off, and in the light of Mr. Calafilo's own evidence that the negotiations continue to be constructive, the idea, therefore, that there will be a trial of the 155 seems very unlikely. The next point I want to deal with is the question of the liability issues. Obviously, that's been debated to some extent between the court and Mr. Toledano. When you look at paragraphs 91 and 275 of our Master Particulars of Claim, what you will see very clearly is that our case on control is de facto control by BHP PLC and Limited with Varley. We don't advance a case that BHP on its own controlled the board. Our case is one of effectively joint control with Varley. But the point of our case is, we say that it is PLC and Limited who were controlling their 50%, if I can put it that way, on the board. It wasn't BHP Brazil. BHP Brazil was the vessel that had the right, or the subsidiary that had the right pursuant to the JV arrangements, but the right in practice was exercised by BHP PLC and Limited and was enjoyed by them, and so that's our case. And indeed, you might say, on one view, our case is entirely consistent with BHP Brazil's defence, because BHP Brazil's defence is that they weren't involved in the management of Samarco. They state it in terms. They say, well, we were the shareholder, but we weren't involved in the management. So to that extent, one might say there's actually coincidence of position. I accept that there could be some overlap with the BHP Brazil defence to this extent. You may recall that BHP Brazil takes the point that, well, we are not liable because we don't control the board. It's a rather, it's the perfect defence for 50-50 shareholders, because it means that either of them can say, both of them can say, neither of us controls the board, therefore we're off the hook. But leaving that aside, I can see that in theory, it is possible that BHP PLC and BHP Limited also take that defence in the English proceedings. I'm prepared to accept intellectually that that's possible. That could be something that also arises in the English proceedings. So that, in relation to the question of indirect polluter liability via the control route, insofar as it is a defence for a shareholder to say, well, I was only a shareholder and no more, that sort of, you might say, a fairly narrow point, I can see potentially there could be some overlap. But it would be limited overlap, because our main case on control is not based on the mere fact that we ultimately owned 50% of Samarco. It is based on the fact that we were able ourselves to, or rather BHP PLC and Limited were themselves appointed the directors to the Samarco board and directed the relevant individuals. Mr. Toledano spent a little while analysing the position if there were a settlement of the 155. A settlement of the 155, in my respectful submission, has got nothing to do with Article 34, because a settlement of the 155 would not involve a judgment on the merits in relation to the out of the related actions, such as to give rise to a risk of irreconcilable judgments for the purposes of Article 34. In
Is
theory,
it legitimate even at the C stage?
I beg your pardon?
Is it? Well, perhaps I'm using the term wrongly. Is it illegitimate to? I assume you must be right about the premises for the discretion arising. But could the court not say we expect there may be a judgment which will give rise to irreconcilable judgments? Now we've got to decide how to exercise our discretion. And is it irrelevant at that stage to take into account as one of the factors in the exercise of the discretion, what if the expectation doesn't arise, and there isn't a judgment, but there is a settlement? But is that not something that goes into the mix?
That, in my respectful submission, is not really it's not what Article 34 is directed to.
No, I understand that, but it's a little bit artificial to ignore it as one of the possibilities.
It could be that a possibility of settlement might be relevant, for example, from a case management state perspective. But that's a different point. If you think about Article 34, the purpose of it is to avoid or to minimize the risk of irreconcilable judgment. So what it is therefore looking at is the event in which there is ultimately a judgment. And it requires the discretion then to be exercised in such a way as to effectively to promote the proper administration of justice, primarily in the member state court, but obviously having regard also to whatever may be apparent as to what is going on in the third state court. But the concern or the purpose of the discretion is to manage the risk of conflict. The possibility of settlement, in my respectful submission, has got really nothing to do with it.
Doesn't this rather bring you up against paragraph 97 of NES, approving paragraph 206 of the judgment? I think you've accepted that we should proceed on the basis that that's right. I can see that if we were starting from scratch, the contrary argument would be just the one you were putting now. But
well, you can take. Forgive me.
Justice Flo seems to have said, approving Mr. Justice Turner, that once you get to the discretionary stage, you're not limited to factors which are confined to irreconcilability factors. You can look at it more broadly.
Oh, I can see that, but the factors in question, the factors you take into account, must still relate to the purposes of Article 34. The purpose of Article 34 is to enable. It is certainly one, prevent the manage the risk of irreconcilable judgments. Obviously, that's one of the primary risks. It's also obviously to enable the proper administration of justice. But to start to exercise it by reference to the possibility of settlement, which by definition, if it were to materialize, would not give rise to any risk of irreconcilable judgment. It's a much more difficult proposition, in my submission. I'm certainly not aware. I'm certainly not aware of any authority.
I was going to ask you, has there been any
Well,
where settlement has been expressly considered, prospect of settlement has been expressly considered? Because you'd have thought it would come up all the time. There's
Well,
always,
absolutely.
nearly always a prospect of settlement.
Absolutely. I'm certainly not aware of such an authority. So I'm not aware of it having been cited by or sort of highlighted by anyone.
Now, I see the time, Mr.
Yes.
Choi. Anything else you feel you have to say?
I think I can deal very shortly with FNC, if I may, in 5 minutes.
5 minutes
Would that be
it is.
acceptable? I appreciate asking for an indulgence. Yes. Before I forget, before I move on to FNC, I do have a handout that effectively comments on Mr. Toledano's handout. If I can hand that up. Oh, it's already in your bundle, as I understand it. I think it's been placed behind your Mr. Toledano's handout.
I see, okay.
New CPA.
The new CPA, exactly.
New CPA.
Yes, exactly.
Okay.
Sorry, so
Do you
where's it
want
gone?
to look at it now?
Would you mind just
Well, it's up. All right, we'll
Very
look
quickly
now,
look
but
at
I don't.
it.
Not to take time out of your 5 minutes. So you've got to decide what. Where is it?
it's immediately behind Mr. Toledano's note.
Yes,
where
I
is
don't know
that?
where's that?
Tab 94.
Sorry.
Which one? Q.
Q94, and it's gone in at 4332.1. If it's the document, I think it was.
I think.
Yes, I see.
Right,
Yeah,
yes,
thank you. Yep, well, we've got it now.
Thank you very much.
Well, unless you want to spend your 5 minutes walking us through it, I think you also have to trust us to read it.
Yeah.
Okay.
And I just want you to. I just ask you to bear in mind, essentially, 3 points in relation to the new CPA. One is, I will move on to FNC, but I think it's important as well for you to be aware of the arguments in relation to the new CPA. Number one, what they are proposing is extremely elaborate. There's no case that I'm aware of where Article 34 is being relied upon and consolidation alternative is being relied upon, where essentially in order for there to be consolidation, large groups of claimants have to, as it were, entrust their claims to some representative party who will then start some new CPA on their behalf. There's no such case, as far as I'm aware. Number two, if you are satisfied that there is no real prospect of a trial of the 155 CPA, then the entire new CPA proposal and the consolidation proposal simply doesn't make any sense. It's a road to nowhere, essentially. And number three, and this is the biggest problem with the new CPA idea, is that a CPA, if unfavourable to the victims, will not be binding in any event, so that they can carry on with the claims that have been stayed. And you have to ask yourself, how is it necessary for the proper administration of justice to go down such a contorted and artificial route? And we say the short answer is no. And all of that, of course, is the only reason why we are engaging in this bizarre exercise of all the multiple ways of multiple CPAs, associations to be established for a year, and other CPAs, is because they want to be in Brazil, they don't want to be here. That's the bottom line. And
If you're, I thought you just made
FNC.
3 points. You made them. Yeah.
So on FNC, the key point I ask you to bear in mind is this, that on the question of choice and Lord Briggs's adjustment, you can't rely on your own choice as giving rise to a risk of irreconcilable judgments, and then rely on that as a trump card. But number one, you are entitled to point out that the risk of irreconcilable judgments is an important factor and is not to be ignored, number one. Number two, the critical issue here, and this is not a point that Mr. Gibson has really addressed, is that it's not just the risk of irreconcilable judgments that is the relevant FNC factor in a case such as ours. What is critical in our case is that the causes of action against both PLC and Limited are identical. They are essentially the two arms of the same person, and because of the DHP structure. And what that means is, if there is going to be a trial against PLC, as one presumes there will be, because there's nothing that can take away the right of the claimants to sue PLC in England, if there will be a trial against PLC in any event, irrespective of the risk of irreconcilable judgment in relation to which Lord Briggs's adjustment is to be made, irrespective of that, all of the logistics of the trial and the build-up to trial, all of those will already involve matters such as need for Brazilian law, translation of documents, witnesses, same witnesses having to give evidence and being available, and such like. So it's all of the build-up to the trial and the trial itself, quite apart from the risk of irreconcilable judgment, that are effectively identically engaged.
That is using, I'm sorry, that is using Vedanta as a trump card.
It's with respect, it's not, because in Vedanta, for example, the causes of action, for example, against the two defendants were different, whereas here the causes of action are identical, and that in my respectful submission is an important distinguishing factor, because it does. I agree with you. It may also lead to a risk of irreconcilable judgments. I agree.
It will do so all the more.
Well,
those are the identity and the causes of action.
That
greater the risk of irreconcilable judgments.
That may be so. But non-constat that when you're looking at the conventional FNC factors, where are the witnesses, language issues, and so on, non-constat that you are not allowed to look at those to understand whether a trial against one of them will engage those things. It may work differently in different cases. There can be some cases where the level of the degree of similarity or identicality is different. But it so happens that in our case, it's almost a complete overlap. But there are obviously other points, such as it would be sufficient, for example, for one claimant or a small number of claimants to be able to proceed against BHP Ltd in England. It could be, for example, because it's not feasible, practical for let's say, a particular group of individual claimants to have access to legal aid and such like, and to be expected to sue in Brazil by themselves. And if any of them were able to sue on their own in England, that would mean in that event that BHP Ltd would face a trial in England in any event. So that, therefore, irrespective of the risk of irreconcilable judgment, other claimants, in my respectful submission, that might otherwise not be able to say so, would be able to say, well, we are entitled to point to the fact that BHP Ltd is facing the self-same claim by other claimants in any event. I mean, that's particularly relevant, for example, in the context of the other side saying, well, you should go and form an association and then sue in Brazil. Now, if you look at that, for example, well, there's no real choice when you have to form an association in order to be in a position to have a choice in order to pursue a particular type of proceeding, for example. So so we do ask your lordship to bear that in mind. Moreover, insofar as
moreover, but I mean you had 10 minutes so far.
I'm sorry.
Well, I really don't want to be schoolmaster about this, but we're giving you an indulgence. You've got to be. How much more are you really going to be?
I just have one final point.
Well, can you make it? Yeah.
I'm grateful. So the final point I wanted to make was that if you look at the other type of proceedings that they say the claimants can bring, i.e. individual proceedings, you are obviously entitled to take into account the fact that in that context, that will simply lead to a huge multiplication of judgments or a huge risk of inconsistent judgments, which must be capable of being taken into account in the FNC context. I think if I say anything further,
I'm not going to stop you if there's something really crucial you've got to say, but if it's really just elaborating points you've made already, it's too late for that.
I'm very grateful. So, it's fair to say that there were also issues raised about case management stay, but we've dealt with that in our skeleton.
I think you better rely on your skeleton on that. Well, it may, unless my lord or my lady have any other points they want to ask. Yes,
My Lord, on a happy note to end on, if I may, and thank you for sitting early and late. The good news is that the beauty salon owner, I'm instructed, can make a claim under the novel system.
wonderful. You're going to give us a reference.
Well, I mean, given it, I did ask for that. And, so perhaps
I doubt if the case is going to turn on the beauty salon.
Well, I
don't know.
expect that. But it's nice to end on some good news.
Thank you. Well, we're very grateful for the careful and cogent submissions of all counsel, which obviously reflects a great deal of work done by those behind them as well. And we're also grateful for how well organised the bundling and all the administrative arrangements have been. We will, of course, be reserving our decisions. I had better say, though I think everyone in court already knows, that what that means is that in due course draft judgments will be circulated to counsel for the so that where possible they can agree consequential matters, and where they can't can provide short written submissions dealing with such matters, so that we can make an order at the time of formal hand down. Also, of course, to draw our attention to any typographical or other minor errors. Recent experience has shown that counsel won't need to be told that it is sometimes not fully appreciated that that is the only purpose for which draft judgments are circulated, and they should only be circulated to those people who need to see them for those purposes. So that should be borne very much in mind. Thank you again very much.
And sorry, we're going to get the final list of all the references by Monday morning, are we, please?
Can we do it? Yes. Yes, my lord.